Think about what's in your backpack right now, not the obvious stuff. Think about all of it. Your phone, maybe, a wallet, headphones, notes from work or class, receipts from the last few weeks, a charger, maybe a notebook with things you wrote down that weren't meant for anyone else, personal medication, personal anything. Your backpack is not just a bag, it's a portable version of your life. Everything you carry close to you because you need it or because it's too personal to leave somewhere. Now imagine someone reaching for it without asking. Not threatening, just reaching. Calm, matter of fact, like it's a perfectly ordinary thing to do. And before you've processed what's happening, a hand is on the zipper. Do you know what your rights are in that moment? Not what you think they might be, not what feels right, what they actually are. Because here's the thing. When most people picture Fourth Amendment protections, the constitutional protection against unreasonable searches, they picture cars, traffic stops, glove boxes, and trunks. That's the context where this topic usually gets discussed. But a backpack isn't a car. It's on your body. It's personal in a way that a car simply isn't. And the rules around searching it, when it's legal, when it isn't, what you're required to allow and what you aren't, are things almost nobody understands until they find themselves in a situation where understanding them would have mattered enormously. There's a version of this story that happens constantly. Someone is in a public space, a transit station, a park, a shopping area, a street corner. An officer approaches. There's a reason for the contact, a general inquiry, a response to something in the area, a routine check. The officer is professional. The conversation is brief. And then, "What's in the bag? Mind if I take a look?" And the person who has nothing in the bag, who has never been in any kind of trouble, who has absolutely no reason to refuse, says, "Sure, of course, go ahead." Not because they're required to, because they don't know they're not. And what they don't know they're not required to do is the entire subject of this video. Before we get into the legal detail, I want to be clear about framing. This is educational content. Understanding the rules around backpack searches doesn't make you adversarial to law enforcement. It makes you an informed person navigating a situation that most people encounter without adequate preparation. The vast majority of officers do their jobs correctly. What this video is about is equipping you with the information to know what's happening when it happens. Now, the law. The Fourth Amendment protects against unreasonable searches of persons, houses, papers, and effects. Your backpack is unambiguously an effect. It's property you own, carry on your person, and have a reasonable expectation of privacy in. That expectation of privacy matters in Fourth Amendment analysis. Courts ask, did you have a genuine expectation of privacy in the item or space searched? And was that expectation one society recognizes as reasonable? A backpack that you're carrying, that is closed, that contains your personal belongings? Yes. Courts have consistently recognized that people have a reasonable expectation of privacy in their personal bags. What does that mean practically? It means that in most circumstances, searching your backpack without your consent requires legal justification beyond, "I'd like to see what's in there." Specifically, a warrant, probable cause, or circumstances that fall into established exceptions to the warrant requirement. The exceptions matter. Let's go through them honestly. The first is consent. If you agree to let someone search your bag, the constitutional question largely disappears. What's found is legally obtained. This is the one that applies most often in everyday encounters, not because officers always have other justification, but because asking is easier than establishing justification, and most people say yes. The second is probable cause. If an officer has genuine, articulable facts that create a reasonable belief that evidence of a crime is in your bag specifically, that can provide legal basis for a search without consent in many circumstances. A vague hunch doesn't qualify. Something they can point to and explain does. The third, and this is the one that surprises people, is a limited exception from Terry versus Ohio. Officers who have reasonable, articulable suspicion that you're armed and dangerous can conduct a pat-down of your outer clothing to check for weapons. This does not automatically extend to opening and searching a closed bag. The Terry frisk is narrow. It's about checking for weapons on your person, not conducting a full search of your belongings. The fourth is incident to a lawful arrest. If you're being lawfully arrested, officers can search your person and the area within your immediate reach, which can include a bag you're carrying. But this is tied to an actual lawful arrest, not just an investigatory stop. The fifth is school settings, and this one is genuinely different. The Supreme Court's decision in New Jersey v. TLO established that in schools, the standard for searching a student's bag is reasonable suspicion, rather than the higher probable cause standard that applies elsewhere. This is a real, meaningful reduction in the protection that students have compared to adults in public settings. Here's the practical picture that most people are missing. In a public, non-school setting, if you're stopped by an officer who asks to look in your backpack, and there's no arrest happening, no specific articulable probable cause they can point to, the legal basis for that search often comes down to whether you agree. You are generally not required to consent. I don't consent to searches of my bag. Said calmly, said clearly, said without a long explanation attached. That's the response that preserves your constitutional protection in the moment. The social pressure to say yes is real. The officer may seem surprised. The question might come again, phrased differently. The energy of the interaction might shift. None of that is a legal obligation to comply. Let's talk about the way the request usually comes, because it's almost never framed as a formal request with legal implications. What's in the bag? This is an observation invitation, not a search. You're not required to describe the contents of your bag to an officer who has no legal basis to search it. A neutral answer or no answer at all is equally available to you. Can I just take a quick look? The word just is doing a lot of work there. It minimizes the request, makes it sound like a trivial thing. It's not trivial. It's a consent search request, and your agreement matters. Open it up so I can see, not a question, framed as an instruction. Many people comply because it sounds like something that's going to happen regardless. It isn't. You don't have anything in there, right? So this isn't a problem. The guilt inversion framing. Your right to decline a search doesn't depend on what's in the bag. It exists regardless. It'll make this a lot faster for both of us. The efficiency argument. The implication that cooperation speeds things up. In practice, declining typically resolves just as quickly, and with your protection intact. Every version of this request gets the same response. I don't consent to searches of my bag. The full phrase toolkit for backpack encounters, in order. When asked what's in your bag, I'd prefer not to discuss the contents. When asked if they can look, I don't consent to searches of my bag. If a search proceeds anyway, I'm not consenting to this search, but I won't physically resist. If you're unsure whether you're being detained, am I being detained or am I free to go? If detained, I'd like to speak with an attorney before answering questions. Those phrases, that sequence, practice them out loud right now, not as a mental exercise, but actually saying them, because the muscle memory of saying them calmly is different from the cognitive work of recalling them under pressure. Now let's run through some specific situations, because the general principle is one thing and real scenarios complicated in ways worth knowing. What if you're a student and it's a school context? The legal standard is different here. Schools operate under the reduced, reasonable suspicion standard from New Jersey v. TLO. That means a search of a student's bag generally requires reasonable suspicion of a rule violation or law violation, lower than the probable cause standard in public settings. This doesn't mean schools can search any student's bag at any time for any reason. There still needs to be reasonable suspicion specific to that student, but the protection is genuinely weaker, and students and parents should understand that. If a school search feels improper, if it seems to lack the required reasonable suspicion, if it was conducted in a way that seemed unreasonable, that's a conversation to have with a parent, and then potentially with an attorney after the fact, not something to resist in the moment. What if you're on public transit and there's a bag check operation? Some transit systems operate voluntary bag inspection programs. The word voluntary is legally significant. You are generally permitted to decline and leave the system instead of submitting to the inspection. This varies by jurisdiction and specific program, so knowing your local rules matters. If the inspection is framed as a condition of entering the system, not a search but a term of access, the analysis is different. What if your bag is in your car during a traffic stop? A bag inside a vehicle is subject to vehicle search rules, which are different from the rules around a bag on your person in public. If officers have probable cause to search the vehicle, that probable cause may extend to containers inside the vehicle, including bags. This is different from consent. If you consent to a vehicle search, that consent can extend to bags inside the vehicle. If you don't consent to the vehicle search, the bag's protection depends on whether independent legal justification exists. I don't consent to searches covers the vehicle and everything in it when you decline a vehicle consent search. What if the officer performs a pat-down and claims to feel something in the bag? A Terry frisk is limited to checking for weapons on your person. An officer patting down your outer clothing may feel the outside of a bag you're wearing, but that pat-down of outer clothing doesn't automatically create the right to open and search the bag's contents. If an officer claims the pat-down revealed something, that claim can be examined through legal process. In the moment, I'm not consenting to this search, but I won't physically resist. Let the process work afterward. What if you're at an airport or border crossing? Different rules entirely. Searches at border crossings and international airports operate under significantly different legal standards. Courts have recognized broad government authority in these settings that doesn't exist in ordinary public spaces. This video's framework doesn't apply to border and customs situations. Those are a separate legal category entirely. What if you're at a festival, sporting event, or venue that requires bag checks as a condition of entry? These are typically private property conditions of access, not Fourth Amendment searches. You can decline the check and decline to enter the venue. The constitutional analysis doesn't apply the same way to private property access conditions. What if the officer says they have probable cause to search your bag? Your non-consent remains your position. I'm not consenting to this search, but I won't physically resist. Whether actual probable cause existed is a legal question determined by courts, not established by the officer's statement in the moment. Your non-consent is part of the record. If probable cause genuinely existed, the search proceeds on that legal foundation, and your refusal doesn't invalidate it. If it didn't, your refusal matters for any legal challenge that follows. Let me spend a moment on something that tends to get overlooked in these conversations. The backpack situation is emotionally different from the car situation for most people. A car feels like a mechanical object. A backpack is personal in a different way. It's on your body. It has your things in it, your actual daily life, the stuff you carry because you need it close. There's something more viscerally uncomfortable about someone reaching into it than there is about someone looking in a glove box. And that discomfort produces a faster, more automatic compliance reflex. People hand over their bags before they've even processed the request. Understanding this about yourself, understanding that the automatic compliance reflex moves faster in this context, is what lets you interrupt it. Not to be difficult, not to create conflict, but to make a conscious choice about whether you're agreeing to something rather than just reacting to the pressure of someone reaching. That choice belongs to you. It always has. Here's the summary. Clean and short, because clean and short is what sticks. Your backpack generally carries a reasonable expectation of privacy under the Fourth Amendment. In public, non-school settings, a search of your bag typically requires consent, probable cause, or specific legal circumstances. Without those, you're generally not required to allow it. "I don't consent to searches of my bag," said calmly, once, without elaboration. If a search proceeds anyway, "I'm not consenting to this search, but I won't physically resist." Schools operate under a lower legal standard. Know this if you're a student or a parent. Airports, borders, and private venue access conditions are different categories entirely, and the backpack in your car is subject to different rules than the backpack on your person. Now here's what I haven't addressed yet in this video, and it's actually what I want you thinking about between this video and the next one. We talked about when police can search your backpack. The answer involves probable cause, consent, specific circumstances, and context. But there's a different question that's less often asked. When can they search what's inside your phone, which is, for most people, more personal than anything in any bag they carry? Your phone isn't a bag. It isn't a container. Courts have specifically addressed it as a different category of privacy protection. And the rules around it, what's permitted, what isn't, and what most people do that inadvertently removes their protection in that moment, are things that almost nobody walks into that situation knowing. That's what comes next.